I think that Lord Mance is the appropriate person to answer that question, because he is in the process of writing a book about the history of the Privy Council and the Judicial Committee in particular, with his judicial assistant.
Thank you very much indeed. And can I say at the outset that it's a pleasure and a privilege to be able to speak to you, Dr. Henry, and to those in Antigua and Barbuda who are listening to this. The project which the President has just described derives from a visit I paid last year to the Bahamas, which I know well from practice, and to the Cayman Islands. And in the Cayman Islands, it was suggested that there was some mystique about the Privy Council that wasn't entirely cured by our rules, and that a fuller guide would be helpful. And so I said I would consider this. And when I suggested it to my judicial assistant, he said, well, we must write a book. And so we are indeed doing just that. And I, in fact, have the first chapter, which I was discussing with him this morning, which deals with the history. So to turn to your question, the history goes back a very long time, to Norman times, to the original King's Council, which had every conceivable sort of function, including, of course, legislative. But by the Tudor times, the king had become extremely unpopular through overusing the power of the council and the Star Chamber, and a determined attempt was made to abolish everything except the ordinary courts and the overseas jurisdiction of the Privy Council, which survived. And that was regularized in the late 17th century and further reformed by a great reforming Lord Chancellor at the beginning of the 19th century, Lord Brougham, who introduced the acts under which we currently operate. That's the 1833 and 1844 acts governing the Judicial Committee of the Privy Council. There was a further act in 1876 which introduced the law lords in the House of Lords, who effectively from then on sat as the Privy Council, together occasionally with members of the Court of Appeal, and subsequently overseas Privy Councillors also sat. So that's a brief history. The function of the Privy Council has always been to administer the relevant laws, not necessarily always the common law. There are still jurisdictions. The Mauritius is the principal one, but St. Lucia also, which have a civil law tradition, and in the past there were many other laws, including Roman Dutch. But for the main, it's common law, and of course common law differs from jurisdiction to some extent. I think it wasn't just a one-way traffic in history. The Privy Council has operated a dialogue with its jurisdictions, which I think and hope has been mutually enriching. We still have about 30 jurisdictions which choose to serve us. Some of them, of course, are Crown dependencies or British overseas territories for which that is automatic, but there are other territories like independent countries like yourself, which use us, including two republics, that's Mauritius and Trinidad and Tobago. It's entirely their choice, but we are very happy to do the work. It constitutes about 30% of our workload now, and we give, I think in the last year it was 47 or 48 judgments, which is about half the number we give in the Supreme Court. So I hope that's a brief and useful oversight of the history.
I think that any court has a certain amount of mystique because people have to respect the court and when they give evidence or when they come and appear in it, they have to respect the court. But I think mystique, which makes people frightened or means that they don't understand what goes on, is not right. And I think what the Judicial Committee of the Privy Council has been doing over the years, and if you go back into the mists of history, as Lord Mance described, has succeeded in doing, is to bring itself up to date from time to time. And while I appreciate in particular that if you are in Antigua and Barbuda, you look 3,000 miles away to London, it looks a bit far away, we do try and make ourselves as available, as transparent as any court can be. And one of the purposes of us being here today is to try and explain and blow away any misconceptions about the Judicial Committee of the Privy Council. What we do is perfectly simple. We hear appeals from countries, from states which are happy to come to us and treat us as their final court of appeal, which is a great honor for us. And we want to ensure that citizens, companies, governments, individuals who want to come from those countries to our court, to the Judicial Committee, feel that we are there to serve them, there to hear their cases, and there to give judgments which we hope are readily understandable. And we do not like the idea of having much mystique, and do our best to try and avoid having it. I think some of the countries that are currently come to the Judicial Committee of the Privy Council will not in the foreseeable future be in a position to or want to de-link. I think in the case of countries such as Antigua and Barbuda, the answer to your question is that we are very happy and proud to serve them as their final court of appeal, if and so long as they wish us to. In this modern democratic age, every country has ultimately to decide democratically what its fundamental constitutional features are. And if a country such as Antigua and Barbuda decides that it wishes to de-link, then once that decision is appropriately constitutionally and democratically taken, then it should de-link. But so long as it does not want to de-link, we are very happy, very proud to serve it, serve such a country as its final court of appeal. Yes, and that's what they decided, and they are the best judges of their own constitutional setup, and we respect that. It's not our function to try and persuade or let alone try and force anyone to submit to our jurisdiction. We are, as I tried to emphasize, there to serve the countries and states which wish to continue to use our service as a final court of appeal. I can assure you, as the President of the Judicial Committee, and I'm confident that I speak on behalf of all my colleagues, that so long as a country wishes to have us as its final court of appeal, we will serve it as conscientiously, as carefully, and as appropriately as we serve any other country, including the United Kingdom, as its final court of appeal. Speaking personally, and I think this applies again to all my colleagues, it's not only a compliment, but it's a pleasure and a privilege to act as a final court of appeal on behalf of jurisdictions which are not only those of the United Kingdom states. It's a great pleasure to learn and experience from other countries such as Antigua and Barbuda, from which we, I think, benefit and learn a lot. And as I say, it's a privilege to do so, and we will do so long as we're asked to. But once it's decided democratically, if and when it is so decided, we will obviously stop. But until then, we will continue. I certainly don't take that view. I think that as far as I'm concerned and as far as my colleagues are concerned, I can only repeat that we are happy to continue to act as a final court of appeal. I do not regard Caribbean appeals as taking up too much of our time, and I haven't got Lord Philip's statement in front of me, but if he said that, that is certainly not the case now, if it ever was.
We've sat in the Bahamas at least 3 times. I myself have been there on those occasions twice. We've also sat in another jurisdiction, that's Mauritius, 3 or 4 times. And mutually, those have been, I think, very valuable and informative occasions where we've met not only the judiciary, but also members of the bar, members of the local justice ministries and others. And when I say judiciary, at every level. In principle, those were, I think, very welcome from both ends. The cost is, of course, substantial and is something which had to be borne by the local jurisdiction insofar as concerned travel and accommodation for the justices and for a small support team. That's really the rationale of that, was that we were sitting at the invitation of the local country. In this jurisdiction, our services are cost-free, except for, of course, for the court fees, but they're cost-free to the local government, which as whose final appeal court we're acting. So in a sense, there was a small quid pro quo there. In order to reduce the need, perhaps, to think in terms of a visit, although we've offered to visit when requested, we do aim to make ourselves entirely accessible by video, both during hearings and through our video archive service. And I think the use of video for hearings is something which needs also to be pursued. We're about to, later this year, conduct a video hearing from Mauritius. We're conscious of the inevitable expense in travelling to the UK and obtaining visas and accommodation, or indeed instructing counsel in the UK. And I can come back to this point, but it's not actually necessary to instruct Privy Council agents over here, for example. And of course, it's not necessary to instruct UK counsel. We very much welcome overseas counsel from the relevant jurisdiction, and we do see quite a lot of them, I think in 60% of cases. We do have provisions in place to ensure access to justice. For example, in criminal cases, there are no fees payable to the JSPC. In civil cases, the fee does depend on the value of the amount in issue. And we do, in the Privy Council, see a very wide range of cases. We see cases ranging from heavy commercial cases, constitutional cases, down to quite small cases. So the amount of cost in terms of fees is to the court is very much dependent on that. There is power, and it frequently is exercised, in the registrar to waive court fees to parties who can't afford them. And as a final... Sorry. It's done when it's necessary. I can't give a percentage, but it's certainly something we see quite frequently where individuals say that they cannot afford it. The registrar has that discretion, and if need be, it's reviewed by justice. There is also a facility for UK counsel to be asked to act where a local party simply can't afford any sort of representation here, to act free of charge as a sort of amicus curiae. And we have used that on a number of occasions.
I think it's also relevant to say that our offer of video hearings should reduce costs very considerably when it's taken up. It hasn't been taken up very often, and maybe we should make it more publicly known and more clearly known that it's available. But we are very happy to have hearings with the advocates and the parties and the solicitors in Antigua and Barbuda, and the judges here having a hearing a bit like the present interview is taking place.
Yes. It's absolutely not necessary, no, and it's not necessary to have London Privy Council agents as it used to be. It's no longer necessary. We regularly do receive applications and appeals from attorneys in the Caribbean, and very often we receive and hear cases where advocates from overseas come and appear before the Privy Council. We've also recently, from last year, altered the basis on which costs are recoverable which are incurred in preparing in the overseas country for a Privy Council hearing. Previously there used to be restrictions on that. They have now been lifted, and necessary costs are recoverable. So we are conscious of the problems of access to justice. No one can reduce a distance of 3,000 miles, but we are certainly conscious of the difficulties and are aiming to try and meet them.
Yes, I can understand that, but that is one of the reasons why we are keen to make available our video system, so that people don't have to travel here, don't have to incur travel expenses, don't have to incur hotel expenses, and can have a hearing like we're having now.
It's about, I think, 25 or 30 cases a year. Most of those, I think about 2/3, come as of right, and sometimes the limits in local constitutions are quite low, I think generally so, but the rest come by permission and depend upon application to us. I suppose about 20 or perhaps 25 applications a year, of which we grant 1/3 on average. Remarkably consistent average, actually, not by intent, but simply by considering each case on its merits. It works out at about that.
As for the rate of disposition, it depends to some extent on, first of all, how long between the appeal being lodged and the hearing of the appeal, and secondly, how long it takes to produce the judgment. But in one or two cases where the matter's been urgent, we've managed to dispose of it very quickly. Lord Mance, for example, had a case recently which was very urgent and was disposed of, he will tell you how quickly, very quickly. When it comes to the gap between the start of the issue of the appeal and the hearing, to some extent it depends on the availability of counsel. The advocates and the solicitors sometimes want the hearing delayed, sometimes the parties do. But when it comes for the gap between the hearing and the judgment, it's normally a matter of no more than a couple of months. On difficult cases involving lots of facts, where there may be disagreement among the judges, it may be longer, and on urgent cases or small cases, it may be shorter. But I think Lord Mance can give you an example of a very quick disposal of a case.
Yes, I can probably give two examples, but we do deal with matters on paper when they're interlocutory applications, whether for a stay or for an injunction or for an urgent permission to appeal, informally and very quickly. And please don't take my previous reference to a mystique as suggesting that we haven't already, some years ago when we moved to this building, reformed our rules and had in mind the need to streamline them and make them practical. So coming to particular cases, I can certainly think of, firstly, your near neighbours, St Kitts and Nevis, where we dealt with an important issue relating to electoral boundaries and a proposed change to them as a matter of urgency, issued our decision, reserved the written reasons till later and gave them later, and ensured a result whereby the election took place upon what we considered were the correct boundaries, which were the old boundaries rather than the proposed new ones. That's a case that attracted a lot of attention on video link. I think we had 5,000 hits when I gave the initial announcement of the judgment, and I think overall many more, a very large percentage of the population of St Kitts and Nevis. Another case we've had more recently over the Christmas and New Year involved, didn't come from the Caribbean, but it involved a series of urgent applications for stays, and it involved a hotel in Macau. In fact, it was an appeal. There was an offshore-owned hotel. So we do, I hope, rightly pride ourselves on dealing with that sort of application expeditiously and informally, and issuing decisions which really matter to the parties. Yeah, there are two categories really. Firstly, there are the cases that come to us as of right under the constitution of the relevant country. And we hear them as of right. There is a formal procedure whereby the permission as of right under the constitution has to be confirmed by the local court of appeal, but assuming it confirms the permission as it should do if it's as of right, then it comes to us automatically. The only circumstance in which we can decide not to deal with the appeal is if we conclude that it has absolutely no prospect of success. That is a very rare case. It has happened once or twice. So that's the first category of case. The other category of case is the category of case which, under the local constitution, requires permission to appeal, what used to be called special leave. In that category of case, we have to consider whether the case is an appropriate one for hearing by the Privy Council. And that does depend, to a degree, upon our view of the merits and also upon the importance of the case, whether it's a case sufficiently significant to be considered at the highest level. It may be a case which is better left to the local court of appeal, which has no doubt issued a judgment. In that category of case, there are, as I said, say 20, 25 applications for permission to appeal from Caribbean countries each year. There are more, of course, from other overseas jurisdictions. And on average, we grant about 1/3 of those applications. So if you add the cases which are as of right to the 1/3 of the cases which get permission to appeal, you get a total number of cases heard each year of about 25 to 30, and those are the substantive appeals. Now, the process up to the hearing of the substantive appeals is all done on paper in practice. The substantive hearing of appeals is done in person or, of course, we hope in future, increasingly by video link. I hope that gives the picture. Yes, we obviously know members of Caribbean judiciaries, including members of the Caribbean Court of Justice. In fact, we know them not just from their judgments, but we know them in person, and we very much welcome. That is absolutely right, and I think the last was Mr. Justice Zaka. But we, in principle, are very happy to sit with overseas members of the Privy Council who are qualified. The point I was going to make about visits in person, we do very much welcome visits to the Privy Council here in Parliament Square, and we're delighted to entertain foreign members of the judiciary to lunch, and would invite them when in London to make themselves known, make the visit known, and as I say, we would certainly be very pleased to see them, and we have done in the past. We also, from time to time, have the chance to visit the Caribbean, and we're very willing to do so. Obviously, that does require an invitation and involves some cost, but I did, as I mentioned, visit both the Bahamas last year, where I met the former Chief Justice and the present Chief Justice, as well as other lawyers, and the Cayman Islands, where I gave the Chief Justice's annual lecture and met not only other members of the judiciary, but also the bar or solicitors out there. And I know my colleague Lord Carnworth was in Jamaica at an environmental conference at about the same time. So in principle, we are happy to travel. I did investigate the possibility of visiting other parts of the Caribbean when I was on my visit to the Bahamas and the Cayman Islands last year, but it's quite difficult, I discovered, to travel around the Caribbean without doing a detour back either down to Kingston or back to Miami. So it didn't occur on that occasion, but I hope one day it might occur.
I think the answer is fairly straightforward. As I indicated earlier, we are very happy to serve as a court of final appeal for any state which wishes us to do so. We also are very happy to provide any assistance and have any discussions with the judiciary of those states. We are very conscious that they are independent countries with their own judiciaries and their own traditions and their own court services. And we are delighted and would be delighted to visit and provide any sort of guidance or assistance or have any discussions if we're invited. But we don't regard it as appropriate for us, as it were, to try and force ourselves onto the judiciary of an independent country unless asked. And I'm unaware of us not having complied with requests to provide services, to provide assistance, to provide guidance. And if we are asked, we would, subject to our being available in terms of time and the money being available, be happy to provide such assistance and have any discussions. When asked, yes. I mean, for instance, at the last occasion the court went to the Bahamas, to which Lord Mance has referred, he went and I went, and we had a seminar, all five of us, five members of the Judicial Committee, had, at the request of the Judiciary of the Bahamas, a seminar at which we all spoke on different topics and took part also, of course, in informal discussions with the judges. And we're very happy to do that, and it was certainly very interesting and valuable for us, and I hope it was valuable for them. That's not the only occasion we've done such a thing. I know that when Lord Mance went to Mauritius recently, he took part together with others of our colleagues in similar activities.
I was also invited in the Bahamas to sit on the bench with the Chief Justice during a call ceremony, which was, of course, a very happy occasion.
And I was just going to say, when I was Master of the Rolls, the head of the Court of Appeal of England and Wales before I got this job, I actually went out to the Caribbean to sit as an additional judge on a question involving judges' pensions, which it was obviously difficult to find a local judge to sit on because they had an interest. And I sat with one of my colleagues from the Court of Appeal and a judge who didn't have a pension from the British Virgin Islands. And that's just the sort of thing which I would be very happy to do, and others of my colleagues would be happy to do. But I do underline the final words, if invited. We have a limited number of judges from jurisdictions, particularly the Caribbean. We are, at the moment, and have been for a few months, possibly over a year actually, been trying to see if we can get round the present formalities that make it quite difficult for people outside the United Kingdom, particularly from republics, to be appointed Privy Councillors so that they can sit on the Judicial Committee. But it's a fair point you make. We would like greater representation of the Caribbean judiciary on the Judicial Committee of the Privy Council, and we are taking steps to try and ensure that that happens. But recently, despite having made invitations, and the last one was Justice Zaka, about, I would say, 6 or 7 years ago. But we've invited, and Lord Mance reminds me, Sean Elias from New Zealand, but we have invited 1 or 2 other judges, including from the Caribbean, to sit, but for reasons of, no doubt, of duties in the Caribbean, they haven't been able to sit. I don't think it's fair on them to identify who they are, but I can assure you that's the position. I beg your pardon. At any one time, the Privy, almost always, the number of judges who sit hearing a Privy Council case are 5. Very occasionally it'll be 3, and very occasionally it'll be 7. But it's almost always 5. Currently, almost always, but not always.
They come mainly from the Supreme Court, sometimes from the Court of Appeal. There are 12 Supreme Court judges and, of course, a larger pool of Court of Appeal judges who are also Privy Councillors.
Yes, of course we understand that. In the first place, we have well in mind that there will be different customs and different accepted social practices from country to country. And indeed, even within the United Kingdom, that's true. And each of us come from one area or another in the United Kingdom, and we have to allow for differences in different areas and differences among different groups of people. The advantage of us being a final appeal court is that we will have substantial input into our thinking from local judges, the trial judge who has heard the case, and normally an appeal court, both in the state from which the appeal comes. And they will, of course, be very familiar with local customs and local social practices, and that will feed into their judgments, and we will know about them. And then, of course, there will often be, and hopefully normally will be, local counsel and local solicitors who will be able to inform us of these factors. And I should add this, there are some advantages sometimes in having a court which is outside a region. It can be more detached in its approach, and while you can say that it's less aware of some of the particular social customs of the country from which the appeal comes, it is more detached and more able to take a detached view of things at times than a court actually in a state. And that may be true, particularly true when the state is small rather than big.
Perhaps I could add also on certain matters such as length of sentence, for example, in a drugs case, or whether there should be a retrial if we've set aside a conviction on the grounds of some problem or failure, we would defer to the local court to a very large extent, and probably in certain circumstances remit the decision to the local court for reconsideration there. So I think, as with any appellate system, one is sensitive to the advantages which judges at first instance or at a lower appellate instance have.
All judges have personal views about things, and those personal views should be put to one side when they are deciding cases according to the law. And I hope and believe that with the quality of judges and the experienced nature of the judges in the Judicial Committee of the Privy Council, we do decide cases according to the law. We do take into account local customs and practices, which are reflected in the judgments of the trial judge and the Court of Appeal, which we will have before us. And we allow for the fact that, as happens in cases in the UK, just as much as in cases from Antigua and Barbuda, that our views and prejudices do not get in the way of us carrying out justice in accordance with the law of the country whose case we have to decide.
Specifically on the death penalty, I think it's right to say that the Caribbean Court of Justice and Privy Council jurisprudence are very much aligned. The Caribbean Court of Justice, of course, had the opportunity to consider the position and issued an important judgment earlier in its career, which broadly followed the Privy Council jurisprudence. So I hope that's also a partial response.
If this is the last question, I'd just like to say that it's been a great pleasure and privilege to have the opportunity of answering your well-judged questions and to have the opportunity, I hope, of explaining to the people of Antigua and Barbuda how we see our role as the Judicial Committee of the Privy Council. Naturally, if there are any other questions you want to raise or any other information you want, I hope we can provide it promptly. And I hope in due course to be providing a 7-minute or so little video giving details of what the Judicial Committee does and why it does it.
No, thank you very much indeed. May I endorse what the President has said. It's been a pleasure and a privilege to speak to you all.
Thank you.
Best wishes.
Best wishes. That's very kind of you. Thank you very much indeed. It was very nice of you to ask your questions so clearly.
Yes, absolutely. No time.
Yes, I'm sorry if I misunderstood one of your questions. Thank you. Thank you.
Thank you.
Bye.
Goodbye.
Bye.